Hey folks, Attorney Andrew Branca here, Dean of American Law Courses, with a very special treat for all of you who are interested in a better understanding, even a mastery of the law. As you may know, I've just launched our American Law Courses, a series of courses designed to replicate the same courses as typically taught in the first year of law school at a law school level. Our scheduled 1L courses include criminal law, which we've just launched with Professor and Attorney Steve Gosney, as well as additional courses launching in the next few months, including constitutional law, criminal procedure, and evidence. We've been offering these courses on a pre-launch basis before classes start at 50% off the usual tuition, and we've been humbled by how many of you have signed up. Welcome to all you Plank owner students of our American Law courses. We understand, however, that for many others of you, there's a certain degree of uncertainty as to how these courses will look and feel and whether you'd be a good fit for such a law school level course. Spoiler, you are, and other similar points of uncertainty. So to strip away that uncertainty and enable you to confidently join us as a student in our law school level American Law courses, I'm here to share with you the first half hour of Professor Gosney's first criminal law class, which we just conducted, so that you can get a concrete sense for how these advanced law courses are run and just what level of expertise our professors bring to their subjects. Now, this is a playback recording of just the first 30 minutes of Steve's criminal law class. Of course, the actual live class was about 90 minutes long, and enrolled students participate in these classes in a live streamed format on a semester basis with a live class every week, with plenty of opportunity for live Q&A with Professor Gosney. And those students also have the option of accessing the full recording of every class should they want to cover the same content again, or in case they were obliged to miss one of the live classes. This criminal law course provides a law school education in criminal law, replicating the 1L first year law school experience in an online setting, but at a fraction of the cost and time of law school and with none of the leftist political ideology that so infects today's law schools. We simply teach traditional American law in the traditional American way, to foster the ability of American patriots to arm their minds by learning the law so that they can avoid being simply taken advantage of by self-proclaimed law experts in the media and government. Now, in addition to enjoying this first 30 minutes of Professor Gosney's first criminal law class, I also urge you, naturally, to learn more about just how these American law courses work by checking out our American Law Courses website. And even better, if you do that right now, we've also extended our 50% off tuition for an additional week, so that all of you have the chance to register as students at the discounted price with the confidence of having viewed this first 30 minutes of Professor Gosney's first criminal law class. That 50% discount saves you over $1,000, folks. Indeed, this brings down the cost of this entire criminal law course to less than what the textbooks alone would likely cost you in a formal law school 1L criminal law course. But this extended 50% off tuition is available only for the next few days. So I urge you to take advantage of this opportunity right now by pointing your browser to lawofselfdefense.com/law courses. That's lawofselfdefense.com/law courses. Okay, folks, with all that out of the way, here, as promised, is the recorded playback of the first 30 minutes of Professor Gosney's live criminal law course. Hey, folks, welcome. I am Attorney Andrew Branca for Law of Self-Defense. Thank you very much for being here. Yes, thank you. We always appreciate the applause. It's greatly appreciated. With me, of course, is Attorney Steve Gosney. Steve is your professor for this criminal law course. We see the attendees are jumping into the course right now. If you don't see that, Steve, you may need to hit the little update button at the top of your attendee list, and it'll start to fill in. You might think of me as the dean of these American law courses. I had originally planned to teach this criminal law course myself, but when Steve volunteered to take that role, I couldn't possibly say no. Steve brings unbelievable experience to this course. Years as a criminal defense trial attorney for the Public Defender's Office, years as an appellate level attorney for the Public Defender's Office, who still trains the trial division lawyers, years before that as a prosecutor of cases. So he's actually been on both sides of the table. I've only ever been on the criminal defense side of things. So I bring a very particular bias to criminal law myself. And with Steve, you'll get both sides of that. In addition to that, Steve is, in his own right, a well-respected and well-read legal intellectual. His law review papers, legal academic papers, are among the top 10% of academic papers out there in terms of rate of citation. So we have a real powerhouse here to teach this criminal law class to all of you. When Steve and me were chatting just before we went live here, I was telling him that the excitement that I was feeling getting ready to launch this course was very much like the excitement I recall feeling when I myself was first beginning law school, waiting those last few months or weeks or days before I finally entered that law school experience. Really, nobody in my family had ever been a lawyer before. It was a completely novel experience to me. The only thing I knew about going to law school was from movies like The Paper Chase. And I was like a thoroughbred horse waiting for the race to start when I got into law school. And I have that same feeling here today for all of you, because this is going to be an unbelievably exciting experience to learn criminal law at this level, a law school level from such an expert as Steve, at a fraction of the cost, a fraction of the time commitment. When I went to law school, it was many, many tens of thousands of dollars. That was 1990, folks. So it'd be hundreds of thousands of dollars today. It was a 3-year commitment. I had no idea if I was going to be any good at it. Fortunately, when I went to law school, the political ideology was fairly low. I mean, you just kind of assumed all your law professors were liberals. That's just the way academic environments are. But it wasn't the kind of, grab you by the throat and choke you until you're unconscious and have submitted political ideology that's rampant in law schools today. And you'll get the opportunity in this criminal law course to simply learn criminal law without being beaten over the head by that kind of political ideology. So it should be a tremendously exciting experience and opportunity for all of you. Again, I was talking to Steve just before we started. This particular course, this first class, is of critical importance for all of you, because this is where we're going. Steve is going to establish the foundation on which all the successive classes are going to sit. And you have a tremendous captain in charge of your ship here. So pay close attention. If you're reasonably attentive, folks, you cannot help but learn an expert level of criminal law from Steve. I should mention Steve has asked me to contribute to 1 or 2 of the classes over the course of this criminal law course. I'm more than happy to do that. But make no mistake, your professor for this course is Steve Gosney. Steve, any thoughts before we hit the top of the hour and really get the ball rolling here?
Nope. Of course, we're going to have question and answer periods that I've built in to the PowerPoints. So if you have questions, do put them in the question section, and it's going to be a lot of fun. We're going to. I mean, it sounds silly, but it is interesting stuff, and I'm going to try to make it interesting. I've gotten some waivers from some clients. I also have some stuff from my prosecutorial days with that you can see some videos that are going to be real world examples. I'm going to try to really incorporate as many real world examples as I can, so that y'all can enjoy the actual from statute to case to all the way to the end to a real world case, and then we can talk about it. So now, as you said, the first class, this is going to be very it's going to be the basic stuff. So what I want to do is give everybody a framework for which they can analyze the law. So you'll see that in this first class is not going to be so much substantive. There is going to be substance, and it's going to all tie together as little threads as we go through. But it's what my objective here today is going to be to get you all up to speed on language of law, how to read things, how to look at things. And this is a real foundational class. So glad you're all here. Thank you, everybody, for signing up, and we're going to have fun.
Hey, a couple of nuts and bolts things. I see a couple people in the chat apparently aren't seeing both Steve and I. It's not really important if you see me. I'm going to be ducking out of this in just a couple of minutes because this is Steve's show. But if you are having any kind of technical difficulty like that, you might try just logging out and logging back in quickly, and that might well fix the problem. If not, Emily will be observing the class. So just put in the chat whatever kind of technical issue you might be having, hopefully none, but heaven forbid one were to happen. Emily is observing the show, so she can contact you and help work through any of that. Also, roughly half of you signed up just for this criminal law course, which is awesome. But half of you signed up for our 4-course bundle of classes. That includes this one, of course, also criminal procedure, likely to also be taught by Steve. I'm trying to talk him into it, and a constitutional law class and an evidence class. So with criminal law, that's 4 courses. We offered those 4 courses as a discounted bundle. If as you go through this class here tonight, you decide you change your mind, you only signed up for criminal law, you'd like to sign up for the bundle, which is heavily discounted, folks, just email Emily at lawselfdefense.com, and she'll be glad to manually extend that bundle offer to you so you can take care of those other courses as well. I don't think I have anything to add until I'm back in the class as a co-instructor for 1 or 2 of the modules. So Steve, I think at this point I'll just turn things over to you, Captain, my captain.
Okay,
and wish everybody
I'm
a great time.
Frozen here. Where we go?
Up there you. All right.
Let me just make sure I've got my files up here. Okay. All right. So are we ready to start?
All right, folks, I hand you over to Steve. Have a great ride. It's going to be great fun, very exciting, and get ready to arm your mind by learning the law. Take care, folks.
Okay. Let's see. We're going to start here. So welcome, everybody. And like I said, there will be break times for question and answer. So my name's Steve Gosney, as he says. And this is basically a criminal law 101 if this is your first year of law school. And this is going to introduce you to the concepts. Now, we're going to cheat a little bit because I understand that everybody here is not a law student. And a lot of times in law school, they like to trick you in their first year. They like to play games and make it difficult and make you struggle and play tricky games, okay? We're not going to play tricky games. We're going to get right to the point, and I'm going to give you examples of how to read statutes, how to read cases, and this is sort of fundamental stuff, so that when we start getting into substantive law and citations, you'll understand that from a perspective of a student who is actually, we're trying to teach you, not just trick you. Okay. So with that, there's some of my introductory stuff. I was a history major at Stetson in 1990, graduated Washington and Lee School of Law in 1999, Master of Science Criminal Justice 2017. And I've been in private practice. I've been in state attorney's office. I'm doing appeals and I'm board certified in criminal trials. So he got to all that. So that's who I am. Now, one full disclosure I do want to make for y'all. That is, I am from Florida. I'm a Florida lawyer, board certified criminal trial lawyer. I will tell you that I don't like practicing outside my jurisdiction. I will add federal cases. I will probably add some out-of-state cases around the country if there are points that I don't think are illustrated in Florida, but there might be a Florida focus here. If there is, I just want to let you know that's my domain. And if you want to know the particulars of a particular state, it might not be quite as applicable, but we are state focused. Does that make sense? Okay. Let's see here. Just make sure, is everybody hearing this okay? Just say in the chat if everything is good. Okay, this is the parts of the machine. What does that mean? Well, criminal law is a machine. It is a machine of destruction, the way I like to say it. What happens is somebody does something bad, and we as a society do something bad back to them. So it's a system, and you'll see the systematic type process concerned with the punishment of those who commit crimes. Now, It's a very negative system. And what I mean by that is there's no productivity. If you work in a factory and you're on an assembly line, you are making a widget. And the widget comes out, and at the end of the day, you have a pile of widgets. Well, in law, at the end of this system, something bad happens to a person. So it is a harm-causing society. Now, we as a group of people, we get together and we decide to offload violence to the government because we don't want the wild, wild west. We want to have violence monopoly given by the system. And the common law and the legal system is set up so that when you run it through that system, there will be something approximating justice to the parties involved. And that means the victim, the society, the defendant, all the parties who may have an interest have some sort of stake in the system. And that's what this is designed to do. Now, it also is a disincentive, like there's a carrot and stick idea. There's no carrots in criminal law. It's all stick. Okay. There's also a segregation idea. And I'm not talking about racial segregation. I'm talking about some people are uncivilized. And there's a theory of humanity. If you have children, when you're a child, you're an uncivilized person. And over time, your parents civilize you and you become attuned to the ways of the society. Well, some people don't have that civilizing process. Some people cannot operate in an environment, a civilized society. So what we do is we lock them up and segregate them from the law-abiding community. It's amazing because when I do first appearances, when you get arrested and you show up to the judge in the first 24 hours, you would think they're in front of a judge, they could conform themselves to polite behavior of society. But every first appearance, there's going to be one or two people who shout, who curse, who don't want to come out and have to be disciplined by the bailiffs. And they can, in the most formal, high stakes environment, they can't conform their conduct to polite society. So it's amazing that they can't do that. But think about how they are when they're in a position of power and there's a victim or somebody who's weaker than them. They're going to take advantage and abuse. So the system has that kind of that dual function, the carrot and the stick. It's all stick, and the segregation element. Now, there's these justifications, and this is sort of philosophy of criminal law. Punishment is the key. But there are other competing concepts, and depending on what state you're in or in what country you're in, you can have competing concepts such as reformation. Some countries, especially other countries, I would say more than in the United States, we try to rehabilitate the offender. That's where you get training programs in prison. And most people that go to prison get out at some point. So you do want those people to become integrated into the society, to learn their lesson, and to become productive members of our community, right? The restraint function is what I just spoke about. And then there's a deterrence function. And this is a concept of that people do not commit crime because they're afraid of the consequence. Now, there's two types of deterrence. There's individual deterrence and there's general deterrence. Individual deterrence means, for instance, you have somebody who commits a rape on a child. And they say, well, why don't I just kill that child? Because if they kill, the death penalty is in play. And if they leave the person alive, then they're not subject to the death penalty. So you would consider that as an individual deterrent to bad action. There's also a general deterrence. That means a society, as a general matter, we don't commit crime generally, as opposed to the specific instance. So I know I'm not going to steal my brother's car because I know generally crime doesn't pay and the cost exceeds the benefit. So that's kind of a cost-benefit analysis in the society. So those are two different kind of deterrent concepts. So those are some justifications for why we have this system. Now, strictly defined, It's a network of government and private agencies intended to manage accused and convicted criminals. That's what, if you want to talk about a definition of criminal justice system. But that is, what are those parts? Well, we have law enforcement, that's police, forensic services. For example, you have labs, crime labs, DNA testing labs. The judiciary, we have judges and corrections, correctional officers. And of course, public defenders, you have prosecutors. All of these are parts of that machine that go to make up that through this debate and integration results in something we consider to be criminal justice. Now, the Anglo system, which is what we are, we're for Anglo means English, so we are from the English system, is an adversarial system. What do I mean by that? Well, you have a public defender or defense attorney who's there to advocate for their client. And then you have a prosecutor who's generally an advocate for the law and is prosecuting. So those two people are clashing in a court, and they're mediated by a judge when it comes to the law and a jury when it comes to the facts. So we think that through this idea of combat and confrontation, that the parties that are viewing the confrontation will be able to decide what the facts are or what the law is, because each side will be putting forth their best case and we'll make decisions on that. Now, there's other systems. Again, in Europe, there's a continental system, the Napoleonic system, which is inquisitorial, not like the Inquisition, like the Spanish Inquisition, although that was an inquisitorial system. That means that the judges are actually doing the investigation. So there's tribal systems, and there is criminal law in tribal systems where you have a tribal elder council, perhaps, that will mediate disputes. They perform the same function as the American Anglo confrontation system or adversarial system. There's theocratic systems, which is like in Iran, where you have the clergy makes these decisions. And in totalitarian systems, you could just have a dictator. Dictator says who's guilty and who's not. So there are competing systems, but our system is an adversarial system, and we have a jury component, which is an English innovation. So what is the law? The first law is statutes. Now, statutes are passed by your legislature, primary source of modern criminal law. I will add, state law, 95% of all criminal law is state law. So you get a lot of people get focused on the federal judiciary. That is uncommon. Most law is state. Most criminal law is state, I should say. And then you hear this word, the common law. What is the common law? Well, common law are basically factual examples that come from application of statutes or application of particular cases over time. So you get courts making decisions in individual cases and applying law to facts. And then over time, you can read patterns in these cases. Well, the courts are doing this particular thing in this particular idea. And over time, it develops into a body of kind of rational legal thought. So common law is really a series of criminal decisions or court decisions that we aggregate and try to derive some greater meaning from the application of that over time. Then if there's a give and take, sometimes the statutes codify the common law, and then the common law develops the statutes over time. So there's kind of a push-pull process that develops. Now, there used to be common law crimes, and some states still have them. Common law crimes that were defined by the judges. Now, Florida does not have that. Most states have a very strong codification of their system, but there's a lot of concepts that come strictly from case law that you don't see. Now, statutory law, again, is the primary, and most lawyers make the mistake of over-investing in case law. And we're going to do a lot of case law stuff, but I'd also want to tell you that statutory law is the foundational source of law, actually, and that is below the Constitution. So the legislature theoretically cannot pass a law, a statute that violates the Constitution. There's constitutional supremacy. Some people argue there's natural law supremacy, meaning that if you pass a constitutional amendment that violates natural law, that is an unlawful enactment. So these are some ideas of sources of law, like where does law come from? Primarily your legislatures, and then the courts applying them in factual and individual disputes. Now, sources of facts. So we say, where does law come from? Most people kind of know that. I know the legislatures passed the law. But where do facts come from? And that's an odd question. You say, what do you mean, where does facts come from? The facts are the facts, right? Except that in a criminal case, very few people are actually present at the crime, especially the participants. The police are usually not there. The judges aren't there. The attorneys aren't there. So what we do is we have a lens through which we view crime. We try to reconstruct what happened factually through these lenses. And for example, police may have been there, may have been present. Maybe they have a body cam video. That would be great, right? Sometimes they don't. But you also have witnesses that were there. You have physical evidence that was derived from the crime scene. You have discovery that maybe the defense can go out and analyze a crime scene or create evidence by saying, we're going to send our inspector out and ask about witnesses or find out 911 calls that were not disclosed to us. That happens a lot. So recognize that the courtroom is an artificial environment that is looking backwards in time to recreate what happened. So when I say source of facts, that is, where do we get the facts that establish crime? And it's from these sources. It's sort of an interesting concept. We'll delve into it when we get into particular cases. You'll see this more acutely. Now, there's also what I call the real world interaction, because we have ideals as people and as lawyers. We say this is the way it should work. But there's also how it actually works. And I want to give you this framework so when we go forward, you'll understand that the concepts we're going to be looking and studying is much more hard law. But we also have sources of power on either side. So it's a power contest in the courtroom. So oftentimes, like when I was prosecuting, I would have a discussion with the defense attorney and say, okay, well, do we disagree on the facts? Or do we disagree on the law? If we disagree on the law, file a motion, we'll argue it for the judge. The judge will make the call, and then we'll go forward that way. Or if it's a factual dispute, maybe you have witnesses that say one thing and we have a different perspective, then maybe that's a jury trial, right? You have a trial that determines what the facts were. But oftentimes, a dysfunctional system, which we will talk about, comes from threats of power from either side, these poles of power. So, for example, a prosecutor will often say, if you file that stand your ground motion, I'll take all the offers off the table. If you file that motion to suppress, then I'm going to take all the offers on the table and ask for jail. I'm going to add additional charges, maybe that because there's so many criminal laws, I can come up with 5 or 6 different charges to add to your pile. I could ask for an enhanced sentence. Maybe there's aggravators there. I can give you carrots. I can say, if you plea, then I'll downfile, or I will let you plead to something less. I'll do away with the minimum mandatory. This is why the prosecutors are so powerful. And these are extrajudicial. They are not law. They are not facts. They are negotiating tactics. And this is extremely common. So unbondable cases is one. We have in the public defender's office, there are certain charges that people cannot get a bond. So that means they sit in jail and rot. So they get arrested for a very serious crime, yet they can't bond out. So what that does is sometimes the prosecutor can just let the time run. Time's on their side when your client is locked up. Now, the other side is true too. So if a defense attorney can bond their client out, time's on the side of the defendants. But sometimes you'll have a client who can't get out of jail, and by the time they they've been in a year and a half, and they'll say, plead to the felony and get time served. And then so he's already done the time before any guilt has ever been assessed. And the client says, you mean I can get out if I just plea? Okay, I'm pleading and I'm getting out. So the fact that somebody is incarcerated without a bond is a huge factor. credit for time served. That's what we're talking about. Now, the defense side, you've got there's other things that play into it. Like, okay, my guy did it, but maybe the victim's his wife. Maybe it's a domestic violence, and he knows his wife's not going to prosecute him because he goes to work and he's the breadwinner and she wants him out of jail. So first appearances come along and they'll come into the courtroom and say, he didn't do it. Let him out. I lied. And the prosecutor will drop it and they'll get out of jail. Sometimes they won't drop it. Sometimes they'll try to force the wife to testify against the husband. Time and delay is generally thought of as being in a defense advantage. It depends on the case, but people's memories fade with time. People's interests fade with time. Witnesses tend to move and lose. Defense side has the beyond a reasonable doubt standard. If you have a client who's smart and doesn't talk to the police, sometimes you say, well, have you accounted for all the scenarios that possibly could result in a not guilty verdict? Sometimes you'll get your client will tell you all the facts of the case and they'll say, and you'll have a scenario that the state hasn't considered. So you can whisper, hey, here's what really happened. And get your client a down file or maybe even a dropping the case. There's circumstantial evidence rule, which, again, if it's just circumstances, sometimes the circumstances work to your client. Now, the laws are changing very against the defendant. Circumstantial evidence rule, which we'll talk about in a future class, may not be as fine. I'm going to give this as a lot of stuff. I'm giving it to you like a fire hose, but I want you to understand that the reality behind the law and the facts is also this power play. Okay. Now, when we talk about, you probably remember from maybe social studies, the three branches of government: legislative, executive, judicial. Well, the way that plays out in a criminal law context is the legislature establishes the statute. So they pass a law. The statute defines the crime. The executive, that is the police and the prosecutor. So the executive component in the system is the prosecutors and the police. And then judicial is, of course, the common law and the judges. So you have all three at play. This is where our checks and balances really, where the rubber hits the road on checks and balances. When you're looking at a courtroom and you see a judge, you see a prosecutor, and we're talking law, all three of those are in play and being represented by a party. And then, of course, we're defense attorneys. We're a citizen. We're representing a citizen. Okay, now there's a prior. Let's start talking. I want to give you the framework because I'm going to give you some cases to read and some homework. And it's voluntary. It's what you get out of it. But I want you to understand the priority of law. Okay, this is sort of I'll say, obviously we'd say moral right and wrong, natural law governs all. So if I have a constitution like the Nazi constitution, and it says murder is fine, mass murder is great, well, we would say, even though that's constitutional in Nazi Germany, it would violate a natural law concept. Okay, so I wanted to put that in there to kind of give us that overview. But generally in America, our Constitution is not the Nazi Constitution, it's the federal Constitution. And that is the supreme law of the land. We, the people of the United States of America, in order to establish a more perfect union, right? You've read this Constitution. That is the law of the land. The Bill of Rights, of course, those are our rights that are explicitly stated. That is within the federal Constitution. Federal statutory law, that is when you have the Congress acts and passes a law. Now, there are federal crimes. There's a lot of federal crimes. But like I said, most crime that you deal with on a day-to-day basis, and most of the time when you're dealing with crime in the United States, we're talking state law. But federal statutory law does override state law. We had a civil war about that, if you remember. We were about federal supremacy. And so when we talk in federal case law, there's a priority of case law. That is SCOTUS, which is the Supreme Court of the United States, is the top. And that is actually explicitly listed in the federal Constitution as the top court. You have federal appellate courts. In Florida, for example, it's the 11th Circuit. And then the federal district court. And so that's the trial level federal court. All right. So you have a trial level, an appellate level, and then a Supreme Court level, right? Then below that, then you have state constitutions. So you have a collection of states. Florida, for example, has a Florida state constitution. There's a right of privacy in the Florida Constitution. There is no right of privacy explicitly mentioned in the federal Constitution, but there is a Florida privacy right explicitly stated in the Florida Constitution. So that would take precedence. So you can't have a law passed by a legislature that violates the state constitution. Just same thing, you couldn't have a Congress passing a law that violates the federal Constitution. And state statutory law, again, state legislatures, same concept. It mirrors the federal pretty much, and it depends on your state. But generally, this is going to be mirrored in bicameral legislatures. Some states, I believe Oklahoma, has a unicameral, one legislative body, but most states have also bicameral legislatures, meaning a Senate and a House of Representatives. Then you have the same sort of high priority of state case law, state Supreme Court, state appellate courts, state trial courts. Now, what does this mean for a criminal lawyer or somebody who's practicing criminal law?
Okay, folks, that's what we wanted to share with you today, those first 30 minutes of Professor Gosney's live criminal law course, and how awesome was that? As mentioned at the start, this particular class actually ran for just over 90 minutes in its entirety, and the total criminal law course consists of fully 14 of these classes taught live on a weekly schedule throughout the fall semester, so through mid-November. I expect that enjoying those first 30 minutes of Professor Gosney's criminal law course piqued your interest to learn more about just how these American law courses work. And you can do that by checking out our American Law Courses website. And even better, if you do check out the American Law Courses website right now, we've also extended our 50% off tuition for an additional week so that all of you have the chance to register as students at the discounted price with the confidence of having viewed this first 30 minutes of Professor Gosney's first criminal law class. That 50% discount saves you over $1,000. Indeed, this brings down the cost of this entire criminal law course to less than what the textbooks alone would likely cost you in a formal law school 1L first year criminal law course. But this extended 50% off tuition is available only for the next few days. So I urge you to take advantage of this opportunity right now by pointing your browser to lawofselfdefense.com/law courses. Now, our American law courses are an unparalleled opportunity for American patriots just like you to arm your mind by learning the law, to get an expert law school level education in the law at a fraction of the cost and time commitment of actual law school, and with none of the leftist political ideology that so infects today's law schools. I look forward to having a bunch of you take advantage of this tremendous opportunity and seeing you in an upcoming American law course soon. Until then, I remain Attorney Andrew Branca, Dean of American Law Courses. Stay safe.